Opponents of litigation finance have recently stepped up their calls for amendments to procedural rules that would mandate the disclosure of litigation financing agreements. The U.S. Chamber of Commerce, perhaps the most outspoken critic of litigation finance, has collaborated with more than 24 other business groups to call for amendments to the federal rules of civil procedure to require the disclosure of outside financing arrangements. But these demands for disclosure reform lack a coherent rationale. This is not the first time opponents of litigation financing have sought rules changes to require disclosure. In 2014, business lobbyists asked for similar amendments, but the Federal Rules Committee rejected that request. In their renewed petition, these business groups argue the expansion of litigation financing demonstrate disclosure is definitely needed now. The U.S. Chamber and their business lobbyist allies contend disclosure will make it easier to assure third-party financing is not used improperly. In this connection, the business groups reiterate the familiar arguments against litigation financing. It may violate the common law doctrines that prohibit the stirring up of litigation, and they may promote the litigation of unmeritorious claims. The question is whether these old arguments will gain any new ground. The former United States District Judge explains why these arguments should not and why the disclosure of litigation finance agreements is unwarranted. Judge Vaughn served as the Chief Judge of the U.S. District Court for the Northern District of California and who retired in 2010, points out that if you put in all the disclosure requirements that had been talked about, where do you stop? Plaintiff contingency fee arrangements are a form of funding, and law firms have financed their receivables for years. Do you then require a firm to disclose it has receivable financing from Bank of America or Chase? Judge Walker noted his former court had recently amended its local rules to require limited disclosure in class action cases, but he characterized the change as modest in terms of actual impact on cases. Moreover, the disclosure of funding arrangements for the class representatives in class action cases is different because it pertains to questions about class certification, specifically to the representative's ability to represent the class's interest. This is a consideration that is beside the point in any non-class action. As Judge Walker points out, in the ordinary case, there is no principal difference between a litigation funding arrangement and a contingency fee arrangement. Just as there is no reason to disclose a contingency fee agreement, there is no reason to require the disclosure of a litigation funding agreement. If you need help with litigation funding, call or email me today.